Ready? Exercise number 5, Series B, Legal Matter. Start. The appellant is seeking anticipatory bail in connection with CR number 865 of 2020, registered with Mohol Police Station, Solapur, District, Solapur, under sections 418, 465, 485, 486, 488, read with 34 of the Indian Penal Code under bracket for short IPC bracket out, and under section 63 of the Copyright Act 1957. Subsequently, section 103 of the Trademarks Act 1990 is also applied. Stop next para. The first information report under bracket for short FIR bracket out is lodged by one Prakash Gaur. He was a zonal manager of Jain irrigation system. His company received complaints that substandard goods in the name of their company were sold in the market. The informant received a secret information that one Eicher truck bearing number GJ03/BV-9840 was carrying goods in the name of the complainant's company, which actually were not genuine goods. That vehicle had started from Gujarat and was going towards Karnataka. On 19/12/2020 at about 4 p.m., the informant and his associates saw that vehicle. They made inquiries with the driver, Jeevan, about the goods. He informed that the goods were loaded from Terraflow Company, Ribada, and he was going to Charchan. He showed invoices. The invoice mentioned 4 different HDPE pipes worth rupees 94,485. The informant physically saw those goods. He saw that some goods were bearing mark Jain HDPE bearing a stamp of CML under bracket Certificate of Manufacturing License bracket out 7018761. That stamp was a forged stamp. The goods were being transported and sold using fake trademark, and therefore he lodged this FIR. The investigation was carried out and the goods were seized. Stop next para. First point for consideration was whether the offence under section 63 of the Copyright Act and also subsequently applied section 103 of the Trademarks Act were bailable or non-bailable. Sri Soman invited my attention to the order passed by the learned magistrate wherein co-accused were granted bail on the ground that section 418 of IPC was bailable, and therefore bail was granted to the co-accused. Perusal of that order shows that the learned magistrate has only referred to section 418 of IPC. He has not considered application of section 63 of the Copyright Act and section 103 of the Trademarks Act. Sri Sonam claimed parity with co-accused in this case. Stop next para. It can be seen that in both these sections, sentence of imprisonment extending up to 3 years can be imposed. The question raised by Sri Soman is whether the offence in which sentence of imprisonment up to 3 years can be imposed falls within third category of part 2 needs to be answered first. For that purpose, I have heard all the learned counsel. Stop, next para. In this case, whether there is infringement of Copyright Act, attracting punishment under section 63 of the Act is a matter of investigation, but certainly there appears to be infringement of the trademark registered in the name of the informant's company. Therefore, commission of offence punishable under section 103 of the Trademarks Act is clearly made out. The accused have falsely applied the informant's trademark to their own products and have attempted to sell those products. Thus, the act of the accused also amounts to offence under section 420 read with 511 of the IPC. By their act, the police were induced or an attempt was made to induce the public to buy these products under the impression that they were manufactured by the informant's company. Stop. Thank you very much.